Good afternoon, everyone. My name is Kristen Solis. I am one of the mentor attorneys here at the Dallas Volunteer Attorney Program. Welcome to our monthly CLE. This month, we are going to be learning about how to probate a will. For those of you that are not familiar with DVAP, as we affectionately call ourselves, we're a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private pro bono attorneys that will work their case from start to finish. We take a wide variety of cases, and one of the most common types of cases that we see are folks coming in to need probate help. Usually it's a situation where a parent has passed away. Usually the only asset is a house or a very small bank account. And of course, they can't get clear title or access to that bank account because they'll need it for food and rent and that sort of thing without taking the will to probate. So we are always looking for folks that will help do the probate of the will. So if you are interested in taking one of these cases, please contact Maricela and she will get you in contact with the person that can set you up with taking a case. So today we are blessed to hear from Melinda Hartnett. Melinda is a partner at the Hartnett Law Firm and specializes in probate work. She is a graduate of Hockaday School here in Dallas, and she got her bachelor's degree from Hamilton College in New York, and then her law degree from Fordham Law School, also in New York. She's practiced in Syracuse, New York, before returning back to Dallas in 2003, joining her family firm, the Hartnett Firm, and she became a partner in 2008. She is one of my mentors in the area of probate. So anytime I have questions, she is the person I reach out to for help. So she is vastly experienced in this area. And we are very blessed to have her tell us all about how to probate a will. And if you have questions during the presentation, put them in the Q&A at the bottom, and at the end of the presentation, Melinda will try to get to as many as possible, assuming time allows. So without further ado, I will turn it over to Melinda.
Great, thanks so much. Hi, everybody. I already see a mistake on my title slide. I didn't change the date from last year. I've done this presentation several years in a row. Hopefully, you're primarily people taking it for the first time because there are similarities to last time. I will say that Judge Monroe attended last year and was so kind afterwards to go through some of the slides with me and give me some updates on Court 2's procedures. So the date is, I just missed changing that, but there are changes to this slideshow. So hopefully I can get that changed before it gets sent out to you. So as you heard, I'm with the Hartnett Law Firm. We do a lot of probate litigation, trust litigation, guardianship litigation. We do also handle simple probates and get appointed as administrator, that kind of thing pretty often. And since we contest wills, we also want to know how to probate wills. So something we've done here for a long time, and hopefully can give you some tips and give you a guide for how to probate wills if you take one on from DVAP, which I highly recommend. I'll talk about it more later. The best way to get some experience is to take these cases, get in front of the judges, and figure it out. They often have unique fact patterns, and sometimes it makes it a little harder, but you will learn so much more. And there's a lot of us here willing to help you get through that process. So the topics I'm going to cover is your first look at the will, the information needed. We're going to go through a simple probate of a self-proved will, a simple probate of a non-self-proved will, issues to look for, what to do after the will is probated, and some tips that might help you in your practice. So I have this little comic strip. This is kind of typical if you practice in this area at all. Everybody thinks they're going to get along with their family members, and then it does not always work out that well when there is money to fight over. And it doesn't matter if it's $10 million or if it's $10,000, they will find a way to fight. And sometimes you're in the middle of that, but hopefully can avoid it with some of these simple will probates. Okay, so when you have your will probate, you're going to get the will, and the first thing you want to look at is the first page. And I then look at the signature and date. I want to know how close to death was this will signed? Does the signature look questionable in any way? And it's just a real quick glance. You're not trying to figure out, is this a forgery or anything like that? But does it look like we have a super elderly person, or sometimes even signed with an X? I've had that before. Just get a quick glance at it. Does it have the witnesses? Does it have a notary, especially if you're on the self-proving affidavit, because that's required. Texas now allows a one-step signing where the witnesses and just sign at the bottom of the self-proving affidavit. I honestly haven't seen that many of those, so I don't know how many estate planners added that to their practice. It's been several years now, quite a while, but I haven't seen that many wills signed with the one-step signing. And then look at the specific and residuary bequests, get an idea of what you're dealing with. Look at the executor provision. Is there an executor named? Are they named independent? And does it have the language needed? It used to be if it said without bond, that was considered enough. And now the courts want to see some additional language to make it independent. And then I always look at the rest of the will just to see what else is going on. Are there any other questions? Does it dispose of all the property? That's a big issue, especially with someone who does their own will or a handwritten will, a holographic will, which we'll look at some of those. They don't always, common things in a holographic will. They don't appoint an executor, or they don't make it independent. They don't have enough of the language. And does it dispose of all the property? They, give their house to somebody, but they didn't think about their bank account that has $1,500, and now you're in trouble. Are you sure it's an original signed will? This used to be an easier test than before. There used to be, we didn't have copies that was that good. Then there was a spit test where, you would wet your finger and see if it's smeared. None of that really works that well. You're kind of just on your own, try and figure it out. There's ways to look for pen, it has the pen depressed it. And probate court 2 with Judge Monroe, he was known for having a high-powered printer's loop and a light table to verify if it was an original versus a copy. And I can tell you, we have gotten that phone call from Judge Monroe saying, I got news for you, your will is not an original. And he knows. But he did recently retired. We now have Ryan Troby has been appointed the associate judge, in case you haven't heard. So I don't know if that will continue, but he was well known for inspecting the wills to make sure you have an original. And then look at the self-proving affidavit. That will dictate whether, what kind of witnesses you need for the will and how many for the probate and how many, which we'll talk about in a little bit. I'm going to show you a holographic will we dealt with in our practice, which it was a will contest involving James Street, a well-known Texas quarterback, and had substantial estate, but decided to do a holographic will. And you can see this one's dated 1999, and it was pretty thorough. It's long, but then he's scratched out and written not will and added some things on the side that, you have a question, was that added later? Is that valid? And you go to the back of the paper. We have a few more. This is not my will. Then I leave everything to my wife. This is not my will again. So that was a fun case with a lot of questions about what is a valid will, what has been revoked, and how would it be distributed. We did settle that case. So let's look at a more typical, simple will. So here you have your will, last will and testament. You have the name of the testator. You can see quickly in the disposition of the residue, gives it to my wife, all the rest in residue. There's a backup to his children who are named in equal shares. I look at the executor provision, section 3, appointed as independent executrix. Next paragraph has the key language that no executrix shall be required to give bond, and no action shall be had in the probate court or any other court. So that is the language that we need to ensure that this is an independent administration, which is far preferable over a dependent administration. We look at the executrix powers, always worth, taking a glance at, not super important first thing when you look at it. And then we look at the last page and you can see it's been signed. It was witnessed by 2 witnesses. And we have the self-proving affidavit there on the right with the witnesses' names listed, signed by the testator, signed by the witnesses, and notarized. I can see there's a little black line through subscribed. That's just something in the pasting. It was subscribed and acknowledged before me. So that looks like a valid self-proving affidavit. If I looked at this and assuming even if he passed away that close, if these are kids in the marriage, this goes to his wife, I'm not going to have a lot of questions about this will. It looks like a simple probate. So I'm going to show you a video from one of our cases. We try and just spice these things up a little bit. This gentleman was actually under a guardianship we were involved in, and then it got lifted unbeknownst to us. And a private investigator started to help him. The private investigator helped him lift the guardianship, actually. And then, of course, he and his assistant ended up getting all of the estate. And you're going to see this interview talking, the private investigator is the person shooting the video and will speak on the video and give false information. And this was a witnessed will. So having a witness isn't everything.
Okay, Buford, you just finished signing your will, right? Okay, and we have witnesses here as well. Cherie is here again to notarize it, right? And we have the 2 witnesses who are witnessing your signature, okay? And you're aware of what the will says,
Yes.
and the fact that you're making bequests to several different people. There's a large bequest to either a foundation or a trust fund or something that will then distribute money according to your wishes. You've left things to me and to Irene, and you've left things to about 5 or 6 other people specifically named in your will, right?
Yeah.
Okay. Now, you signed the will. Were you coerced into making it? Did somebody
No.
beat you or force you to sign it?
No.
I noticed that you have in there a specific thing about your cousins.
Yes.
Okay, you've left them out.
On purpose.
Why?
Because they didn't want me to have a country to live in. That's the best reason I can think of.
What do you mean?
Well, they told the judge that they agreed with everything he did and took everything I had away from me for no reason that I could see.
So you intentionally left them out of your will?
Intentionally, you bet.
Okay. You can add whatever you want to say. You're fine. That it?
Well, that's it.
Okay. All right. Okay, today is August what'd you say? 13th? 13th. Okay, 2015. Okay, thanks, Buford.
You may have noted he didn't exactly answer what the date was. And he said that a substantial bequest to a foundation or a trust or something like that. It was pretty close to 0 what the foundation was going to end up getting. And the PI and his assistant were getting millions. All right, so you've got your will, you know what you need to do. Now you need to get some information for your application. Basic information, date of death, date of birth, the decedent's residence, the applicant's residence, the last 3 numbers of the social security number and driver's license of the decedent and the applicant, if you can. If you're not able to get it, you can say that, but for your applicant, obviously you should have it there. Decedents sometimes don't have a driver's license or you don't have that information. You're going to find out if the executor is qualified, and we're going to talk about that on the next one. These are questions you want to ask beforehand. Does the executor live in Texas? If not, you have to have a designation of resident agent on file with the court, or your executor can't be appointed and you'll have to come back. It's always a good idea to ask about who are the heirs at law, and does everybody agree? Are there 5 kids and only 3 kids are listed in the will? It doesn't mean the will's not valid, obviously. It doesn't mean there's a will contest, but you might want to know what you're getting into. Again, if this was a will done 30 years before and something happened with one of the kids, or it's going to that child's children instead, so some grandchildren, it may be that everybody's on board and understands. But if not, if the will looks at all suspicious, it's holographic, it's close to death, it all goes to one kid over everybody else, you may want to think about whether you take that case or not. Of course, you want to look and see if it's self-proved, because that's going to make a difference in your application and what you plead. Is there a power of sale? Does the executor have a power of sale? May not need it. Everything may get distributed out to the heirs, but if not, you need to plead make that pleading to get a power of sale and get consents from the beneficiaries. You may need a death certificate. Last I knew, it was required in court 3. I'm not sure if it still is or if the other courts have added it. I mean, you'll hear me kind of say that the requirements of the courts change, and they do vary between the 3 courts. So it's something you can find out as you file your documents if you're going to need it. Again, if it's easy to get, no big deal. If it's not, well, you can have a discussion with the court about that. All right, here are the executor qualifications. Is the executor over 18 years of age? Never been declared of unsound mind? No felonies, although that it's not an absolute bar anymore. I'll come back to that. No misdemeanors involving moral turpitude, and no bankruptcies. So the felonies, if the decedent knew about the felony and still chose to appoint the person, and the court still feels that they can serve in that position, they can be appointed. I'm not sure how many courts are willing to do it, but it is now allowed under the estates code. I used to have under there that the executor had no claims against the estate and the estate had no claims against the executor, but Judge Monroe told me that's not a requirement for an independent executor named in a will. So that was good to know. Also with the bankruptcy, this is not an absolute bar either. All of these go to suitability of an executor to serve, and it's not a bright line test. So if there was a bankruptcy 20 years ago, the person's been successful since then, the court likely would go ahead and appoint them. Now, if they're not doing so well, or if it's been recent, they may not want to appoint somebody to manage other people's money. It could also depend on who the heirs are. These are all questions you really want to ask before you go to court. And it's not a bad idea to ask it from time to time, because I have been in a courtroom and asked those questions and they suddenly remember a bankruptcy or a crime that they say, well, maybe this one's moral turpitude. And I've asked it ahead of time, but you still get to court. But at least you can tell the judge, Your Honor, when we came to court, I didn't know about this. I think she just remembered it. And then you're going to deal with that problem as it comes up. Here's the self-proving affidavit. It doesn't have the notary section at the bottom, so you'd want to make sure to have that. It's substantial compliance. The statute requires substantial compliance. So, I mean, most are the exact language that's used in the statute, but it's okay if there are little differences. But this is what's required in Texas to have it be self-proving. And if it's self-proving, your proof at court is less, and you don't have to have the same number of witnesses or the I'll say quality. It has to go with whether they're independent or not. Okay, so let's assume you have a simple self-proven will and you're going to probate it. You only need one proof of death, and this can be an interested witness. It can be a beneficiary under the will. It can be the executor. It's the simplest way to go. You want to have your oath, which now the statute allows for a declaration, so an unsworn declaration rather than having to be notarized. You need to have your order probating the will. In court 1 and 2 have additional proofs they require, proof addendums that we're going to get to in a little bit, having to do with the executor. If you're in front of an associate judge, you always need a waiver of a de novo hearing. It's a standard form. And nowadays, if it's a Zoom hearing, I think all 3 courts require a notice of virtual proceeding to be filed. The courts now, I believe all 3 of them are requiring your documents to be on file before you get a hearing. It used to be they wanted them 2 weeks before they would cancel. Now they won't even give you a hearing until you have these. And that's because so many people would get to their hearing and have to cancel because they didn't get them in time, or there was a problem with them and the court couldn't review it in time. So you want to get that done as quickly as possible. one issue comes up with the proof of death, who's your witness going to be? In my opinion, put who you think it's going to be. You can always change it. You don't have to wait until you are absolute 100%. This person can come to a hearing. It's who you think it's going to be. And a lot of times it's the executor. Go ahead and do your proof. If you have to change it later, you can change it, but you'll be able to at least get your hearing. So here's a sample proof of death that we did. And I use this form and just go down with yes, no questions. Now, I will say Judge Monroe told me last year, make them open-ended questions. You'll see that on a slide. I haven't done that very often, so I'm going to try in the future. But before he told me that, what I would do, the witness gets sworn in, and I'd say, John Smith, let's say it was your father. I don't know if I said, John Smith died on September 1, 2019 in Dallas County, Texas at the age of 80 years. Is that correct? Yes. 4 years have not elapsed since his death. Is that correct? Yes. And he was domiciled and had a fixed place of residence in Dallas County at the time of his death. Is that correct? Yes. The judge would either, at this point, if it's a Zoom hearing, they usually put it up on the screen. If you're in person, the judge would hand you the original because it's been filed with the court. The document dated December 1, 2010, now shown that I'm showing you here, purports to be his will. Is that correct? And it was never revoked so far as you know. And so I go all the way through each of those exactly as they are written. You could easily turn it around and make it open-ended like Judge Monroe would prefer and the courts may prefer. But you go line by line, have a copy of your proof with you, go through it that way. It's very direct and simple if you do it that way. And then the judge can sign the proof. Here are proof addendum qualifications that are required by court 1 and 2. Saying I'm not now, nor have I ever been declared incapacitated. I haven't been convicted of a felony offense, which gives you an indication, that we know the statute has changed, but oftentimes, it's going to depend on the felony. Resident of state of Texas or filed an appointment of resident agent, not convicted of a crime of moral turpitude. I'm disqualified and not disqualified. So that's an additional proof that is needed for courts 1 and 2. All right, let's spice things up a little bit again. This is another will contest case we had where I believe it's some neighbors are helping the testator with her will.
A whole big bunch of stuff, and we decided that it would go into a residual trust after you make all these other gifts to like MD Anderson, Texas Christian University, Scottish Rite Hospital, the University Hospital Foundation in Oklahoma. Okay. Okay. Now it says in here, let me see if this is okay with you. It says fees and bonds, that there will be some fees for managing this estate. Is that okay?
Right.
Okay, like the bank would charge or something like that? Okay. Now, it says here that on the 30th day, it says Cleo Mason Hamilton.
Right.
And you need to make an X right down here, not up there, right here, right, put your pencil right where mine is. And make one of those big X's there. I'll make an X. That's Cleo, C-L, can you give me an L? E-O. Okay, that's pretty good. Want to try that Hamilton?
Yeah.
Try Hamilton. H, H, A, you remember how A kind of looks like that? Okay. M, H-A-M-I-L, T, can you do an O-N on that now? O-N. Okay, that's fine. That's good.
That poor woman, 9 o'clock at night, you can tell she's exhausted. Okay, so for a simple probate of a non-self-proven will, so it doesn't have that last page where it's signed by the testator, the two witnesses, and notarized, because the actual will itself does not have to be notarized. Typically, it's not, just witness, and then the self-proving affidavits are. So you have a proof of death, as we saw with the self-proven will. That can be an interested witness, the executor, or a beneficiary. But you also need a proof by a subscribing witness or another witness, and that witness must be independent. So it doesn't necessarily have to be the subscribing witness. That's your first choice, and that's best. But if you can't do that, you can have someone else who's familiar with the decedent's signature. You still need your oath. You need your order probating the will. You need your de novo waiver, and you need your notice of virtual proceeding if by Zoom. So here's a proof by a subscribing witness. So this person saw the will signed, and while it's not broken down into numbered paragraphs, I still would go through exactly as it's written, each of those statements. And then this is a proof for a non-subscribing witness to testify to the decedent's handwriting and signature. So personally acquainted with the decedent and acquainted with his handwriting and signature. You show them the document and say it's wholly in the handwriting of the decedent, or the decedent's signature is subscribed thereto. And the decedent was of sound mind, 18 years of age or older, and then the statement of no financial interest in the estate. All right, so the next option is probate as muniment of title. And this is where there's no need for an administration. So you don't need to have an executor or an administrator appointed. It is a unique way of probating a will in Texas. It's not allowed in all the states. So sometimes you'll have to push a little bit when a will has been probated as muniment of title. For that reason, some lawyers don't like them. They think it's just as easy to do an administration. I personally am a fan of muniments of title in the right situation. So especially if there's real property and that's all you're transferring, all you need is a muniment of title. If there's very clear language about who is inheriting, so my children A, B, and C, even if there's a bank account, that should be sufficient. You just may have to push, because the banks are used to, the legal department for the banks really are used to letters testamentary, or letters of administration. And so they will say all day long, that's what I need. And you may have to be involved to say, no, it's not. This is allowed in Texas. So no need for administration. There can't be any debts. If there are debts, you're going to need an administration because they have to protect the creditors. But if you don't have any debts, or people can pay the debt off so that when you're probating the will, there's no debt, that works as well. That's sufficient. You need a MERP release, a Medicaid Estate Recovery Program release. This is a statement saying if the person was on Medicaid, that Medicaid is not making a claim against the estate. It's pretty simple to get. It's at the HHS webpage. They're usually responsive. I've had to follow up by email, which has worked well, and gotten it back, because the last I recall, I faxed it. I'm not sure if that's what it required. They probably have an email version now. But I followed up with that and got the information. And a lot of times they release, if it's not a substantial estate, they'll sign the release. Court 2 requires, if the probate is after 4 years, you're supposed to probate a will within 4 years of death. If not, it is allowed, but only as muniment of title. But if you're beyond the 4 years, Court 2 will appoint an ad litem for unknown heirs to step in and look over the probate. They also require an affidavit, a signed statement that there are no debts in the estate before they'll sign a muniment of title. So a little side note, I just heard about another court recently. Some courts in other counties, not in Dallas so far, have required a named executor in a will to sign a waiver or a consent or decline to serve as executor. I'm not sure exactly what the thinking is. There's been some talk about it on the Facebook Texas Estates Attorney page. But yeah, I just heard about this, another court requiring it. So Something to be aware of in other counties. Obviously, DVAP's Dallas County won't have that issue as of now. And then, as I said, some attorneys just don't like muniments. They think down the road you need an administration. You have to push, you have to deal with the banks. It's just as easy to do a probate. I think you avoid, what we're going to talk about in a little bit, 308 notices, inventory, and there's a positive to that. A little less work, it's a little cheaper, and can be easier in the right circumstance. Here's the Texas Medicaid Estate Recovery Program form that you need. And you just fill that out and they'll send it back to you if they're releasing any kind of claim. Here's the affidavit of no debts and no dissolution of marriage that's required in court too. And if the language is included in the proof, you don't need this separate document. So a lot of times with these addendums, if it's the same person, you can put it in there, or if someone can testify to these issues, then put that in your one proof and just go through, ask the same questions the same way, and you'll be good to go. Okay, so additional issues to look for in your will and your probate. Whether it's an original, as I said, it's a common problem and it's hard to tell. You need to plead additional facts if it's not an original. You have to, the presumption, if you don't have original, is that it's been revoked. So you have to have some testimony that it has not been revoked. And kind of what happened to it. Why do you think you don't have the original and think it wasn't revoked? You have to give notice to all heirs at law. So this is an opportunity for anybody who would inherit without the will to come forward and say, no, that's not a valid will, and here's why, or I know it's not why. So if it goes to, or I know it's not, it's been revoked. So if it's going all to the neighbor, and they just have the neighbor just has a copy of the will, you're going to have to give notice to the children or to the parents or whomever would be the heirs at law. It is not considered a self-proven will. And you can see a cite below that Judge Monroe forwarded to me. So regardless of the fact that that copy of a will shows to be self-proven, because it's not an original, Dallas County will not consider it self-proven. So you have to have the additional proof. And in court too, you will have an ad litem appointed. I'm not sure about the other courts at this time. Last I knew, they were not requiring an ad litem. If you're probating a will beyond 4 years, you have to prove good cause. That has varied over the years, but there's a case not long ago that made it pretty open for a good cause. You generally can't just sit on it and say, I just didn't get around to it. But if there was a reason, I thought everything was a non-probate asset, a lawyer told me I didn't have to probate it. And also if it goes to the next person, so your mom didn't probate your dad's will, and now you're dealing with your mom's estate, you will be able to probate your dad's will because you have good cause for not probating it. You didn't know about it. You didn't know it was needed. That's been found to be good cause. So that's gotten a little more lenient over the years. In court too, you're going to have an ad litem appointment, and then muniment of title is your main option. There is an ability to get an administration if there's good cause and good reason to, and a need to, but primarily it's muniment of title. Is your executor disqualified for any reason? Hopefully they name a successor. Because if they don't name a successor, then you're doing what's called with will annex, so appointment of an executor with will annex, and you need to get people to agree for it to be independent. Does your will not say it's an independent executor? If it doesn't, will the heirs agree to it being independent? The problem with this is if there is a minor beneficiary in Dallas County, you are not going to get an independent administration. The court is going to have to protect that minor, and you're going to end up with a dependent administration. And that's a completely different ballgame. Who are the heirs? If the will says, I leave my property to my children, then you may need a declaratory judgment construing the will. And that'll help you determine who needs to approve of the independent executor, because you don't know who the children are. So you say it's Sally and John, but the court doesn't know that there's David over here who's a kid also. They are going to want some proof about that. And then what I mentioned, you can get letters of administration with will annex, which means you have a will. It's not just a regular administration. There is a will. There just wasn't a executor named in the will that can serve for one reason or another. They weren't qualified. They didn't do an executor. They've passed away or declined to serve. So you can still get an administrator appointed, and it can be independent if you have consents from everybody. Okay, consider, was the will properly witnessed or notarized? This can be a fatal issue. If it's not in their handwriting, if it's holding their handwriting, so a holographic will, like we saw with James Street, doesn't have to be witnessed or notarized. If it is not all in their handwriting, you need 2 witnesses. Now, throwing the notary in there, they can serve as a witness. So if there's only 1 witness to the will, but then there's a self-proving affidavit for the 1 witness and a notary, the notary becomes your second witness and you no longer have a self-proved will. So you should, that signature doesn't count twice as a witness and as a notary, but it can count as your 2 witnesses. Is the will ambiguous? Do you need a declaratory judgment? Hopefully it's a simple will, residue to John Allen Smith, and everybody knows who John Allen Smith is. Are there 2 John Smiths in the family? Do we need to figure out who that is? Is the language vague? Do we need some determination by the court? Holographic, entirely in testator's handwriting. You don't need a witness or notary, but you need a proof for handwriting. And it's perfectly valid in Texas. Judge Monroe made this point, and I experienced it just recently myself. Posted citation says approximately 1/3 are incorrect. You need to look at the posted notice. You know, it gets filed. They order the posted citation. You can see it on the portal. You want to look at it. Does it contain the name of the testator exactly as it's on the will? You may need an AKA. Does it contain the name of the executor exactly as on the will? You may need an AKA, FKA. Also, it should list your pleading exactly as it's pled. This is what I got recently. I had to amend an application for guardianship. It said first amended on the title of the notice, but in the body, it did not say first amended. So we had to get that reissued. I'm hearing more about the AKAs and the courts being real sticklers for making sure everything matches up. So if there's any difference, use an AKA for your decedent so that you're sure that you get it the way it is in the will versus the way everybody knew this person to be, or the way it is on bank accounts, because you want that to match up. So when an executor goes to the bank, they don't say, well, we don't have this person. We don't have John Smith. We have Jack Smith. And so you need to have both of those listed on there. Okay, so we'll look at a few wills and see if we can find the issue spotting like law school. Upon my death, I appoint my beloved wife as executor of my estate and bequeath to her 1/2 of my estate. It's actually handwritten. It's a holographic will. Still got 2 witnesses, so that's great. Not required, but added protection. It doesn't dispose of all the property, right? It says 1/2 of my estate. So where's the other half going to go? So you might probate this will, but you're still going to need an heirship to determine where the other half goes. Also is not an independent administration too. Okay, so here we have a self-proving affidavit. I thought everything was good. This was actually signed in Nebraska, so things were a little different, but I still thought it was, it might get me there for a self-proving affidavit. Judge Monroe was very quick to point out that there is a blank for one of the witnesses, Matthew Rich and blank. He wanted me to then, say he said it wasn't self-proved. I thought, well, I think it might be. I'm going to research this issue. But don't worry, there were plenty of other issues for me not to get my self-proving affidavit. It was actually not sworn to by the witnesses. This is what really got me. It's an acknowledgement. That's not sufficient. It's not sufficient in Nebraska either. So I called the law firm to let them know they may need to look because somebody had grabbed the wrong jurat on there. So that's a problem for the witnesses. It doesn't say that the witnesses are over the age of 14, which is in our self-proving affidavit form. The blank that's not there for the witness. Look at Estates Code 251.104 and 251 that's supposed to be 105 for the self-proving affidavit requirements. So I was stung, but I just had to have somebody testify to his signature. It was fine. Okay, so here we have another will. It's not the entire will. I just took the first page and the last page. And you can look around, see if there's any problems. It's the last will of Avery Franklin, has the real property, has the personal property. The real property under 1, it goes to my niece, Jane Smith. The next paragraph, some other real property to Jane Smith, Sally Johnson, niece Gloria Johnson. Specific personal property, Jane Smith, and on and on. Well, do you see the problem? Do you see why I've included the next page? There we go. Oops, let me go back here. Knows what I'm doing now. Jane Smith and Sally Johnson just happened to be the witnesses for that will. That is likely fatal. If this were the end, and I can't remember if there was a self-proving affidavit, even with the self-proving affidavit, all you could do is get the notary as a witness. There are some ways around it, though. If the beneficiaries are witnesses to the will, it can be cured under certain circumstances. If one witness is disinterested, the other witness may provide testimony that corroborates the testimony. So it's possible that one would be able to. It's possible that one would decline, would not take under the will, and you could use the other witness, but you're also going to have to need a notary there too to serve as the second witness there. So there are ways around it, but it is certainly an issue. And if you see that a beneficiary is a witness or both witnesses, it's a big issue to deal with. It also, for me, would raise some questions about the whole signing process. Here's another holographic will that we dealt with, and this did get probated. And I mean, you know, Texas has a long history of holographic wills, so they're going to find a way. And we have a prefer for someone to be testate, so the court will try to find a way to find it to be a valid will. This is one of Aretha Franklin's wills. She had a whole bunch, and I don't know if the last one or this one or which one was found in the couch. Crazy. All right, so let's do another will. You're probably sick of hearing from me. We'll do another video. You know, having a will done by an attorney can give you some comfort, but it's not the end all be all. The attorneys get hoodwinked. I don't know what you want to say. They can be taken advantage of or be part of the problem. And then here you'll see what's going on. The son is to the side of mom.
It says that you give $25,000 to Kathy.
Well, I can.
Is that what you want to do?
I can. If you've got that down there, I give her money almost every month right now when I get my checks. But I will.
Okay, so you want to give her, now you said before that you wanted to give her $25,000.
All right. If you put it down, I'll do it.
Okay. You also said, now do you want to give her anything else? Is that all you want to give her is $25,000?
If I've got anything else to give her, I'll give it to her.
Okay, all right. Also, Renee Guthrie.
Okay, there's a continuation here.
He's not married.
Now,
He's just his youngest brother.
okay, now if Michael were to die before you, who would you want? Would you want it to go to his children or to go to Lee?
I'd want her to go to Lee, wouldn't I? With,
I would say my children.
well,
Well, would you not want his children to receive it? When we talked before, you suggested to me that you wanted his children to receive it.
You want me to say yes or no?
Malkin, it's your decision totally.
Huh?
It's your decision totally.
If he would die before me,
Right.
I don't think that's gonna happen, so I'm not worrying about that.
The way we have it written here is that in the event that Michael dies before you, it will go to his children. Is that okay with you?
It's all right.
So hopefully you can see some problems in what the attorney was doing. A lot of red flags there, having somebody in the room, the beneficiary, not disclosing that, not making it obvious. He was, I think, wanting to stay anonymously over there. And then she was unable to make some decisions herself, which is a problem. And he was suggesting the answer she should give, both the son and the attorney. All right, I'm sorry, I'm having some problems hitting the space bar. It's not going to the next one. We'll see. Okay, after the will is probated, what do you need to do? Well, first you have your notice to creditors. This is a notice to the world that somebody's been appointed and they have a claim. They need to make their claims. They need to send it to you. We also have what are called 308 notices. This is notices to the beneficiaries of the will, letting them know that you've been appointed and giving them a copy of the will. Now, new this year or last September 1st, they were allowed to do it by qualified delivery method. This means hand delivery by a courier. The mail, which was certified mail, has been allowed in the past, and approved private delivery, which there's some language. You can look at the statute. It includes UPS and FedEx and some other companies like that. This is really helpful because certified mail, you probably know, has been difficult to get the green cards back to prove delivery. So this was an easier step to allow it to be delivered in other ways. You can get a waiver to the 308 notice, which is far preferable, much easier than waiting around hoping that the certified mail gets picked up or paying to have it delivered. So if you have a relationship with the beneficiaries or the executor does, they may be able to get a waiver saying they've received it, they've received the notice, and they know about the probate and that the person's been appointed. It's not necessary to do 308 notices in immuniment of title. After the 308 notices are done, the attorney or the executor, depending on the form you want to use, states how notice was given, that everybody's gotten it, or they appeared. If they appear in the proceeding, you don't have to give 308 notices. Look at that statute and you'll see exactly who gets the notice and how it's given, and then the information for the affidavit. You also have to do, if you have an administration, an inventory appraisement and list of claims. This lists all the probate assets in Texas with their values. You don't include non-probate assets. You don't include, pay on death accounts, right of survivorship accounts, trust assets. And it's only real property in Texas. So if there's property in Louisiana, it doesn't go on the inventory because the Texas court doesn't have jurisdiction over that. You just list the property here. You also, I think this will come up, list the claims the estate has against others. The wording's a little strange. You might think it's claims others have against the estate, but it's not. So it's basically the assets. You don't list liabilities. You don't have to list the real property and what the mortgage is. It's really just an idea of what property is in the estate. It's not as thorough as the 706. It's not supposed to answer every question anybody should ever have. It's just some information on the assets in the estate. And you can do now an affidavit in lieu of an inventory. That is saying that you have given an accounting to all the beneficiaries. And so you're not going to file a formal inventory with the court. It's a way to keep it private. Some people are uncomfortable with filing this at the court, even though the inventories are not on the portal. But it's a way to kind of give some comfort to those that don't want to have to do it. You do still have to prepare the inventory though. So you're kind of in the same boat. Be careful though, because if you are late with your affidavit in lieu, you will have to do an inventory and accounting. So, or inventory and appraisement. With a muniment, once you have your order probating will as a muniment of title, you need to file that order in counties outside of Dallas. If you probated in Dallas County, Anywhere else where there's real property, you need to file that order. That'll be enough. Title companies look in the deed records for these, and they look in the probate records in Dallas. That's why you don't have to do it in Dallas. The muniment itself, that order transfers the property, title to the property. That's why some banks don't quite understand what to do. They'd rather have one person who takes control, but it transfers it. The bank should close a bank account in the decedent's name and distribute it to those beneficiaries listed. After you've transferred the property, you file a report of compliance saying, I've transferred all the property and everything's done. The court can waive the requirement of a report of compliance. Judge Monroe told me that Court 2 will only waive if the applicant is the sole beneficiary under the will. I think I've seen that in other courts and other times. It's not waived that often. A lot of times if it goes to a spouse or something like that, it can be waived. But it's a simple form, just saying that you've done what you needed to do and kind of keeps you on the ball to get it done. Oh, and I don't know what's going on in my space bar. No notice to creditors, no inventory necessary. Okay, so tips here with my last few minutes. The probate manual. Highly recommend getting a copy of the probate manual. It's done by the Probate Trust and Estate section of Dallas Bar Association. It's been a few years since it's been updated, I believe, but they're working on it. It's a great resource for forms. I almost always start with forms from the probate manual. Even though I may have other applications to probate, I don't know what's been taken out or changed. So I start with the form that the probate section prepared with help from the courts, because it's, tried and true. There may be changes, but it's the place to start. So you can purchase that, and you may get it through DVAP. I'm not sure. Go to the court websites. They have more and more forms on their websites to help you. I was looking yesterday as I updated this to see what the courts were saying, and they have lots of forms that, the de novo form, a notice of virtual proceeding. It varies with the 3 courts, how many forms they have and what form they prefer, but it's a great place to start. And, if Court 2 has a lot of forms. If they have one and Court 1 doesn't, I'd go ahead and use the Court 2 form if you need it for Court 1. Use the court staff to the extent you can. You can't call them and ask for legal advice, obviously. They're not going to tell you how to do things, but you should be in touch with them. And, if you're not able to get a hearing, a lot of times they'll tell you why. They've caught my citation before. I'm not asking them, hey, can you review the file? But just be in touch with them. Of course, always be courteous. They've got a lot going on and they're juggling a lot of cases, but they do want to be helpful. They want to help you get your wills probated or whatever it is you're trying to accomplish. Here are the estates code sections that will pertain to the probate of the will. Remember to use your proof for your questioning. There you could see Monroe said, ask direct questions. Have you ever been convicted of a felony, rather than the way I've been doing it. But go down the proof. I've seen attorneys show up and, start asking side questions. No more than what's in that proof is needed. Now, if your witness goes sideways on something, you may have to follow up, pay attention to your witness and their answers. But that is what you need. My very first probate in front of Judge Nikki DeShazo, I had taken my one proof and the judge asked for the proof. And I thought, uh-oh, and I handed her my proof and I had to just do it from memory. She called me at the end and she said, next time go in order on your proof. Well, of course, I was lucky I'd hit it all. I was happy I did it, but always have a copy with you. Be prepared. I keep it on my second screen if I'm in a Zoom hearing, so I'm ready to go straight down the proof. Probate versus affidavit of heirship. This comes in with a lot of DVAP cases, and I'm seeing it more and more in other estates where they decide not to probate the will and do affidavits of heirship, which are signed by 2 disinterested witnesses and filed in the deed records. And they especially work with real property. Title companies do them all the time. I'm really surprised by it. I'm surprised lawyers are using them as much as they are. But with the courts being backed up with so many cases, probate can take a long time. It's getting expensive. People don't want to deal with it. And so I know lawyers who are doing affidavits of heirship. They get them signed quickly and filed. Generally do not work for cash for banks. They're not going to want to see that because there's no order. It's just signed by 2 disinterested witnesses, and I've seen them be incorrect or people lie on them. Don't tell your client how fast you can get the will probated. It is technically ripe the Monday following 10 days after you've had your notice. And maybe long ago that worked. And there are some counties where you can still show up on that Monday and have open probates all day. It doesn't work that way in the big cities. So you're going to want to, temper it and tell them you're not sure. You may have problems with your posted notice. You may have problems with your witnesses. Some of the courts are scheduling in February and March as of right now. It can depend on your matter, but I would not make representations and just tell them, ever since COVID, things have been backed up and it's just a different process and it's going to take some time. There are guides and checklists online, especially Court 2. Lots of checklists that they've put up there, and it's very helpful. Intestacy, if you have a will and there's partial intestacy, or if you take on a case like an heirship, or someone just calls you, always use the charts. You can find the Texas intestacy charts. Professor Beyer has one. Judge King may have his own that he's put out there, or he may use Buyers. I can't remember. There's a bunch of them. Anytime somebody calls me about that, I pull out my chart. I've been doing it a long time, but you can forget who gets it if there's a spouse and parents and no children. This whole thing about separate and separate real, separate personal, community, always use your chart. Virtual hearings, check the court for their requirements. They try to keep those updated and sometimes they can change. They put it online. Court 2 has the 1-minute prove up. I don't know if they still do. I did one. It was fantastic with Judge Monroe. I don't know if I said 2 words. It was wonderful. Has to check the right boxes, but it was great. I don't know if Judge Probate will continue that. Know your court, be prepared, and prepare your client. All 3 courts are different, and you want to be prepared for whatever may be thrown your way. And, sometimes you just have to say, one thing is, Judge, can we put on the proof we have and then come back with this other information or supply this other information to the court? Or you may have to say, Judge, we're going to need some time. We'll get that taken care of when we reset. And prepare your client that you don't know if it's going to get done, because there are all these things like citations that you may not realize weren't done, out of your control, but hopefully you remember to check. So be prepared. All right, last video. This was mainly an audio recording. So decedent was in the hospital and the wife was getting a new will signed and brought in some witnesses. I think some of these were former students that were visiting him, and she thought they could witness the will. Well, one of the students had brought a video camera to get kind of last videos of him and was asking some questions. And so he put his camera down. I don't believe it was intentional. It was recording. So you won't see much here. You'll hear, and we have the subtitle. At some point he leaves. She adjourns the signing and talks to him, and then brings in other witnesses to get it executed later, the will executed.
No. Clearly he understands that.
Yes, it's his wish, or we wouldn't be doing it.
That's what I understand. Now, if this is not right,
You see, there's much you don't know about what has happened.
and
that's what-
and neither does
But it's
Barry.
none of your business. It's personal what has happened, what those girls have done in the past. We are doing exactly what he wants done. And you have no idea what has gone on. And I had no idea that this would come up, that you would call Illinois, and then it says that you and I take everything we got and put in a trust. And the advantage of the trust, those sons of bitches, the advantage of the trust is business. See, if there's any money left, Michael gets it. Now, what they don't know is that this is your wish, but you told them the wrong thing out there. You told them that the girls are in this will, and the girls aren't. Because you told me you didn't want the girls in here, because the girls have mistreated you, and you've given them so much when they were alive. Remember that?
Yeah.
Okay, when that attorney comes back and tell him that these, now you tell him without me saying anything, that these are your wishes because of, that's the way you want it, because you have given those girls so much when they were alive. Will you do that?
Okay.
Okay. You see? But Michael and Susan get it, and your girls don't get it. Now that's what this bitch man is complaining about, because he said the girls have been left out. You see?
Mm-hmm.
And it's what you want, isn't it? That's what you said. You're not going to back out on this, are you?
No.
Good, honey. And remember, Sharon gave me a heart attack. And remember how cruel they've been to me. She went to Shilp and his wife, and told them all these lies. And all that awful stuff that you don't remember.
It's really something, isn't it? We settled that case pretty quickly when we found out about the video. Little comic relief for you. And that is the end of the presentation. I'm going to pass. I think Maricela may be here.
Yes, thank you, Melinda, for that great presentation. I know we're a little bit over the 1 o'clock end time, so I'm going to go through a couple of these questions just quickly. We might not be able to get to all of them, just because we want to be mindful of everyone's time. But for some that are more generalized that I will ask, one question was, how do we file the original will? Do we drop it off at the court or a designated rep for the court?
You know, I was thinking about that. I should add that to my slides as I was talking. I was thinking about that. You scan a copy in and it gets e-filed with your will. I mean, with your application, and then you can courier one down or take it yourself. But they're used to depositing that. And I think it's supposed to be within 3 days. It may be a week. It may have changed, but it used to be 3 days.
Okay, thank you. Once a will is probated, is it publicly available?
Yes, it's on the court's portal. You'll be able to see the application and you'll be able to see the will. And of course, you can see it in person too. So if you have a question about a signature or anything like that, you can go inspect the original at the courthouse.
Are there certain time limits for creditors to file a claim against the estate? Can you deny those claims? And what circumstances can you deny a claim?
Okay, that is a big question. So
Okay.
if it's a dependent administration, if you have a lot of creditors, a dependent administration is not a bad idea, even though it's expensive. They have the notice to creditors, and you can give direct notice for unsecured creditors. If you give them direct notice, then they have a limited time to file a claim with you. And you then make a decision whether to approve the claim or reject it. If you reject it, they have a limited amount of time to sue on it. However, if they don't get notice in an independent, and even if they don't file the claim exactly correctly, it may not be rejected. So that is a difficult question. So I'm just going to kind of leave on that. There are limits. If it's in an independent, the expectation is sort of that you're going to get the creditors paid. You know, I mean, they have to be valid. You don't want to just pay everybody right away, but the expectation is they're pretty much going to get paid.
Okay. Are there treaties or an online site you prefer for forms? For example, the Texas Bar Probate Manual, which you mentioned, Prodocs.
I don't use those. I use I know lots of lawyers do. We just don't here. So the probate manual, I absolutely would be my number one place to go. And then otherwise we just use our forms that we've developed over time. But I know lots of lawyers use those online systems that have the forms for you.
Okay. And then I think you answered this towards the end, but can these probate hearings be done virtually?
They can, as of right now in Dallas. It changes. You know, Tarrant County is really limited on their Zooms. Collin County loves Zooms. They have no problem. They're also fine with you coming in. It may affect how long it takes for you to get a hearing, depending on whether you're doing Zoom or not. So it's always worth the question. It just is easier for some people. And for some people, it's easier to go in person.
Awesome. Well, thank you, Melinda, again for a wonderful presentation. The course number I've included in the chat, and I can go ahead and say it aloud for everyone who needs it. That code is 174-254-054. Again, that is 174-254-054. So we ask you to file your MCLE course credit through your State Bar of Texas profile using that course number. Melinda, thank you again, and we wish everyone a great rest of your afternoon.
Thank you. If anybody has any questions, feel free to email me if I didn't get to them.
Thanks, Melinda. Have a good rest of your day, everyone.
Thank you.